Fisher versus the University of Texas, affirmative action in college admissions. I'm Amy Treat, and this is Scholar's Mate. Hello and welcome to Scholar's Mate. I'm your host, Amy Treat. The issue of affirmative action in college admissions has again made its way to the Supreme Court. The latest case, Fisher versus the University of Texas, is a rehearing of the same issue from 2 years ago. In 2013, the court heard Abigail Fisher's complaint that she was denied admissions to the University of Texas because she is white. The court sent the case back to the lower court for review, and now it has reappeared before the high court, where the justices are expected to rule on the issue itself. Joining us to discuss the case is Melissa Hart of the University of Colorado School of Law. She is director of the Byron R. White Center for the Study of American Constitutional Law. She clerked for Judge Guido Calabresi of the Second Circuit and for Justice John Paul Stevens on the U.S. Supreme Court. She runs the Colorado Law School chapter of the Marshall Brennan Constitutional Literacy Project. She serves on the Colorado Access to Justice Commission and the Colorado Supreme Court's Judicial Ethics Advisory Committee and Board of Continuing Judicial and Legal Education. She is former president of the American Association of Law Schools section on civil rights. She joins us via Skype. And joining us in the studio is Ilya Soman of the George Mason University School of Law. He is author of The Grasping Hand, Kelo versus City of New London and the Limits of Eminent Domain and Democracy and Political Ignorance, Why Smaller Government is Smarter, and co-author of A Conspiracy Against Obamacare, The Volokh Conspiracy and the Healthcare Case. Soman's work has appeared in numerous scholarly journals and popular press outlets. He writes regularly for the Volokh Conspiracy and has served as co-editor of the Supreme Court Economic Review. Thank you both for joining us.
Thank you.
Thank you.
So, Professor Hart, how do you think the justices should rule in this case?
First, as to Abigail Fisher's right to an equal opportunity to compete, she had an equal opportunity to compete. Her application was considered, and it was found that she didn't have the requisite scores to be admitted to the programs that she had applied to. And I think it's very important that she's graduated now 2 years ago from the university, and really there is no remedy that this court can give her. She has moved on. In every other equal opportunity affirmative action case, whether we're talking about Bakke or Grutter or Gratz, sort of the precedent that forms the basis of this dispute, those suits were brought as class actions on behalf of a group of similarly situated people. So there was no reason to investigate the specifics of the individual and to say what is the position in which this individual finds himself or herself. That's not the case here. Moreover, Ms. Fisher's same litigation team has brought 2 other lawsuits in North Carolina and in Massachusetts against Harvard that are going through the district courts now that are appropriately class actions that would give the court an opportunity to consider this question in the near future and to do so with a full complement of 9 justices. Finally, as to the merits of the question, the Supreme Court, when it remanded to the Fifth Circuit, directed it to apply its strict scrutiny standard as articulated in Fisher. The Fifth Circuit did that. The Fifth Circuit looked at the University of Texas's plan, looked at its explanations, looked at the compelling interest in a diverse educational environment, which the court affirmed in Fisher 1 was a compelling interest, and said that it thought applying that standard Texas had adequately justified its use of race as a factor of a factor of a factor in its individualized holistic assessment of 25% of its applicants. So this is, even if you disagree with the Fifth Circuit, and I should say here, if the Supreme Court thought the only way the Fifth Circuit could come out in this case was to overturn the University of Texas's admissions plan, then sending it back down to the Fifth Circuit was a waste of time. And the court often decides these things for itself if it thinks there's only one answer to the question. So by sending it back down, the court suggested the Fifth Circuit can look at this and make a decision based on its assessment of the facts, and it could come out either way. The Fifth Circuit looked at it, it came out this way, and it came out this way applying the test that the Supreme Court had set out and concluded that Texas was applying a constitutionally appropriate consideration of race to achieve diversity that is necessary to an effective educational environment.
Ilya, do you want to add?
Yes, so when this went back to the Fifth Circuit used the words of the test that the Supreme Court said it should use, but it didn't actually apply the test. What the Supreme Court said is you have to closely scrutinize what the university is saying to determine whether they really have a good educational reason for doing this. And the university couldn't even specify why it was they were giving preferences to some groups and not others, in some programs but not others, and so forth. They couldn't specify what the critical mass of minority students that they were supposedly looking for actually is, and they couldn't even provide any real proof that this program of racial preference they've been using does actually have any educational benefits. So while the Fifth Circuit mouthed the right words, they didn't actually apply the rules that the Supreme Court required them to do. And this is important not just at the University of Texas, but for college admissions generally, because of course everybody knows that Supreme Court decisions in this area, their purpose is not just to resolve the specific case, but to establish rules for lower courts going forward. So if you allow the lower court to in effect disobey the rules, you're sending a very dangerous message. As for the question of whether she would have gotten in or not, it's never been required that either the particular applicant or a group as a whole would have gotten in. It's true that at this point it's too late for her to be admitted to the University of Texas, but she has asked for a remedy of money damages for the harm that she suffered to go through an admissions process that was racially discriminatory. And the case was already in this posture when it went to the Supreme Court for the first time in 2013. So the situation is not different today. You can argue, and there's various technical arguments, the Supreme Court shouldn't have taken the case back in 2013. But now that it took it the first time, and we have come out with this very objectionable result at the lower court, there's every reason for the Supreme Court to take it again and finish the job, which is in fact what they have decided that they want to do, I think.
I'd like to remind our audience that you can submit your questions to our guests through our website, www.publicsquare.net, and we'll answer as many as we can live on air towards the end of the show. Melissa, would you like to respond to that?
Sure. So, I mean, of course, it's easy to say with any case that you disagree with, well, they said the words, but they didn't really apply the test. What that means is I disagree with their outcome. In fact, the Fifth Circuit applied the test that the Supreme Court had set out. The Fifth Circuit looked at the university's justifications for using race as a factor of a factor of a factor in its admissions assessment. Race plays a relatively small role in the University of Texas's plan, particularly if you compare it to the plan that was upheld in Grutter by the Supreme Court just 12 years ago, where race was a much more central factor in the University of Michigan Law School's admissions process. And the Fifth Circuit looked at the rationale that the university offered, which is the compelling interest that comes from diversity in education. The Supreme Court has said that is a compelling interest, that the need for a diverse student body serves many ultimate goals, including lack of isolation for minority students, including exposure for all students to a diverse community, which is going to be necessary for leadership after college. There are a range of reasons that diversity is a compelling state interest. Texas explored all of those in establishing its plan. And when it looked at whether it needed to consider race as a factor of a factor of a factor, it looked at the diversity that already existed at the university. It noted that students, particularly African American particularly African American students, reported a sense of severe racial isolation. They were a very small percentage of the undergraduate population. And that in order to avoid that sense of racial isolation and the sense that other students weren't being exposed to that diversity, the university decided that it needed to consider race to the limited extent that it could seek more diversity for a strong educational environment. The Fifth Circuit looked at that, assessed it, and said it met the standard. You may disagree with the outcome, but it's not true to say they didn't apply the test.
Ilya?
Yeah, so again, we have to continue to disagree. They didn't apply the test because, as I said before, the university provided no evidence as to why they needed to include these particular groups, primarily African Americans and Hispanics, but not other groups whose representation at the university is actually much lower. So if, say, I believe something like 10% of the student body being Hispanic and something like 5 to 7% being Black, if that's not a large enough critical mass, then why not all the many other groups, Bulgarians, Swedes, Mormons from Utah, dozens of others you could name, whose representation in the University of Texas is much lower than these groups. And the university has no good explanation why they don't provide affirmative action for those groups. They also have no real proof that the racial preference that they use actually have resulted in educational benefits. In many cases, they can't even define the nature of the educational benefits with any precision. To my mind, the whole notion of using racial discrimination to provide educational benefits is in itself problematic. If you take it seriously, you would perhaps allow in some cases universities to use it not just to promote diversity, but to promote homogeneity. Sometimes there might be educational advantages to having many of the students be of the same background. But if you are going to allow this kind of argument, then you at least have to hold the university's feet to the fire to see if they have real proof that what they're doing really does provide the educational benefits. And the Fifth Circuit simply failed to do that in this case. I would note with regard to Grutter, that program in Michigan was upheld only because in that case, the court decided to defer to the university's judgment on a lot of issues. The whole point of the original Fisher decision 2 years ago is that that kind of deference was no longer going to be given. That's why Fisher was an important decision the first time around and why the Fifth Circuit got it wrong this time.
We're going to take some questions from our viewers. Okay. Well, this is from Bruce Turner. Doesn't Ms. Fisher's argument presume that she's entitled to get into any school she applies to? Who would like to answer that first?
I suppose it may be more directed to me. I don't think it presumes that at all. What it presumes is that she's entitled to a non-discriminatory admissions process. If you require plaintiffs in cases like this to prove definitively that they would have gotten in but for the race discrimination, then probably no plaintiff could ever make a case, including, by the way, an African-American plaintiff complaining about traditional discrimination against African-Americans and other minorities, because since most colleges do not have admissions processes where there are strict rules that if you get a certain grade or test score you will get in, you can never know for certain in advance whether a particular person would have gotten in or not. What you can know is whether they've been subject to a racially discriminatory admissions process.
I don't think that Ms. Fisher's argument assumes that she should be admitted to any school. I think it's more complicated than that. I do think, though, that the question raises a really important point, which is that a lot of these discussions about equal opportunity programs in universities assume that somehow any one of us is entitled to get into university. And the reality is that there are always, particularly at elite schools like the University of Texas, more applicants for the available positions then there are more qualified applicants for the available positions than there are positions. And so it's a fiction to suggest that because one student of color got in, one white student lost a position. That's not the way it works. There's not an entitlement to these positions, and there's not a winner and loser end game to these positions. In fact, a university is seeking to admit a class that has diversity in a whole range of ways. Racial diversity is one of the things that universities hope to achieve. I know at the University of Colorado, where I teach, we are very interested in having a strong immigrant community. Socioeconomic diversity is very important in all universities. The University of Texas cares about that as well. So all of these factors go into picking out of the set of qualified applicants a class that is diverse in a large range of measures. And that's what Texas is doing, and that's what every university is doing. And that's something we need to keep in mind in these discussions. Is it's not as if there's something that we could call merit and then something that we call diversity, and these are two distinct things. We're looking for a diverse and meritorious group of students, and that's what universities are always striving for.
Now we have a question from Laura Hamilton. Race is never mentioned in the Constitution, so why does it play a role in constitutional law?
Well, I think the 14th Amendment, which guarantees equal protection of the laws, was one of the amendments passed immediately following the Civil War to ensure that the freed slaves had the equal protection of the laws that they had been denied through slavery in the course of American history up to that point. So race was a central part of what it meant to talk about equal protection of the laws. It is true that race as an abstract classification is not mentioned in the Constitution, and I think there's a good argument that the Supreme Court's cases sort of went off base sometime between the 50s and the 70s, when instead of focusing on the protection of racial minorities, the court moved to a definition of the 14th Amendment as focused on the classification race, so that we would talk about white people's right to equal protection in the same way that we talked about traditionally politically powerless minorities' right to equal protection. I think that has led to a lot of tension. But certainly race can't be ignored as central to our Constitution in all kinds of ways, and particularly equal protection.
Yeah, so race actually is mentioned in the Constitution in at least two places, in both the 14th and the 15th Amendment. Do I agree it's not mentioned directly in the Equal Protection Clause? Professor Hart is absolutely right, of course, that even in some places where it's not mentioned, everybody understood at the time the 14th Amendment was enacted, and since then that racial discrimination was a central focus of it. That's entirely true. I would quibble somewhat with the very common viewpoint that Professor Hart just expressed, that these cases involving affirmative action should be viewed as, in effect, pitting minorities against whites, because the situation is much more complicated than that. We are not today, and we probably never have been, but today, even more so than in the past, we're not just a society that's divided along black versus white lines. There are many different groups involved, and in particular, when it comes to racial preference in higher education, those who suffer from them are often not just whites, but also groups such as Asian Americans, which are almost never included in these racial preference programs, and therefore suffer because of them, even though many Asian American groups actually have a long history of oppressive discrimination against them. So we are not anymore a society, if we ever were, where there's just whites and then a certain specific set of designated minorities. We have many different groups, and I think it's fallacious to say that these affirmative action programs, they benefit minorities and the only ones who suffer might be whites. Unfortunately, it just doesn't work that way.
Okay, and now it's time for Answer This, where each guest asks a question directly to the other. Who would like to go first?
Okay, I'll go ahead, I guess. So I wonder, do you believe, as many opponents of affirmative action programs have asserted, that even plans like the Top 10% plan in Texas, which is facially neutral with regard to race, but was clearly enacted in order to increase the diversity of the class and increase the number of underrepresented minorities, in particular blacks and Hispanics at the University of Texas, that kind of plan violates the 14th Amendment?
It's a good question, and the answer, I think, is yes, that it does violate the 14th Amendment, that what matters is not the exact words in the government's program or here at the university's program, but rather whether the purpose of it is to benefit one racial group at the expense of another. And I think the 10% plan, it's pretty clear that there was a very strong racial motivation behind it. And certainly when you look at the history of racial discrimination against minorities, sometimes tools were used against minorities that were on their face neutral. For example, literacy tests for voting, but in reality were clearly intended to harm black voters, for example. And I think the same thing is true here. However, I would add that I wouldn't say that all forms of affirmative action are always unconstitutional. I think there might be cases where a very narrowly tailored affirmative action program can be justified because it might be the only way to remedy a great historical injustice committed by the government against the minority group. So in that respect, I differ not only with some other opponents of racial preferences, but also with the Supreme Court, which perversely to my mind has said that racial preference in higher education can be constitutional if they're there to promote diversity, but not if they're there to promote compensatory justice.
Another area where we agree, but can I follow up and just ask, what kinds of diversity programs do you think most universities should be permitted to use?
I think any kind they want, so long as they don't utilize constitutionally prohibited categories like race, gender, ethnicity, religion, and a few others. I would add also that if we're talking about private universities as opposed to public ones, then I think the 14th Amendment doesn't bind private universities, and so they should have a freer hand to use other kinds of criteria.
Professor Soman, what would you like to ask Professor Hart?
So Professor Hart, earlier you mentioned that you thought the standards that Fisher 1 sets up are too restrictive for considering racial preference programs in higher education. What standards do you think should apply? Should a Supreme Court simply say anytime the university thinks there might be an educational benefit, they can use racial classifications, or should there be some kind of higher level of scrutiny than that? And if so, what kind?
So I think the court has gone wrong in a number of ways in this area. Like you, apparently, I think that the court should have accepted addressing a history of racial inequality as a compelling state interest and racial injustice as a compelling state interest for some forms of equal opportunity affirmative action in education. So one of the problems is that we're confined to talking about the educational benefits that flow from diversity. Second, I think that the court went wrong a while ago, but really notably after parents involved in community schools, in shifting the focus from a discussion of programs intended to do harm to a racial group to programs intended to a focus on this notion of racial balancing. So I don't believe that affirmative action programs that are intended to benefit some groups are in fact the same as programs that are intended to harm some groups. I think those are constitutionally different, and that a focus on this notion of racial balancing really moves us away from what we ought to be talking about.
So you mentioned that the key distinction that you would advocate is one between programs intended to benefit a group versus intending to harm one. Couldn't that justify almost any kind of racial preference program? Because even traditional Jim Crow segregation, if you ask supporters of it, what they would say is that their motive was not to harm blacks, but rather to benefit white people. They even argued that blacks would also benefit in some ways from segregation.
So I think that it's legitimate for courts to look behind the arguments that parties are making and interrogate their veracity. I think the argument that the purpose of Jim Crow laws was to help anyone is patently ludicrous. And I don't think that's true with regard to equal opportunity affirmative action programs. I think it's clear that in fact the effort is to remedy past discrimination, to address continuing societal discrimination, and to add to educational diversity, which I do believe benefits everyone, although I really think the purpose of these programs is less to benefit everyone and more to try to address the dramatic inequalities that have developed in our society and that continue to harm people who suffer under a burden of lack of opportunity.
All right, and now it's time for We Agree, where each guest names something the other said that he or she agrees with. Who would like to start?
So I think we agree, at least on a couple things. One is that there are many complex factors that universities can legitimately take account in admissions, that there's no one formula that all schools should use, though we may still disagree about the extent to which they should be entitled to use race, at least if they're public universities. We also agree that there are great historical injustices against certain minority groups, and in some cases, universities and other public institutions might be justified in using racial classifications to try to overcome them, though I think I'm more pessimistic than Professor Hart is that actual universities, as they work in the real world, are either good places to run such programs or are institutionally capable of doing them in an appropriately narrowly tailored and focused way.
Okay. You stole all of the things we agree on. No, I think in addition, I think we do agree that Fisher 1, the court's decision from 2 years ago, established a more stringent test that universities have to follow. Although I think we disagree about whether the University of Texas met that standard, it is clear that the court in Fisher 1 was saying, we don't think universities are doing what they're supposed to be doing, and we want to make it clear that we think what they need to be doing is something more rigorous, or they need to be subject to more rigorous scrutiny by courts than they have been.
Okay, that's all we have time for. We'd like to thank Melissa Hart of the University of Colorado School of Law and Ilya Soman of the George Mason University School of Law for enlightening us on this issue. And thank you for watching Scholars Mate. I'm Amy Treat, and we'll see you next time.